I've spoken before about collecting your fee. Still the number one problem facing most lawyers. It seems to me that there are some ways to deal with this issue that will reduce the importance of the issue to many lawyers. One, when you have an intake session with your client, find out what it is that they want. Find out what it is that they expect from you. And also respond to them. Let them know that what they want is okay, legitimate, rational, or not. If it is not, make sure that they're prepared to fight their principal, PLE, with their principal, PAL, and not your principal, not your capital. Two, make sure that they understand how your law firm works. In other words, the fact that they're calling you at 2:15 does not mean that they're going to get a responsive phone call at 2:17. Let them know how you and your law firm work. Manage their expectations, basically, is what I'm saying. With respect to your fee agreement, and I do urge you all to have a written fee agreement, in the margin, put a signature stamp by the paragraph that talks about the fee. Have them initial it, and you initial it. This is an indication that they've read that paragraph and that they understand it. If they don't understand it, that they've asked you all the questions that they need to ask in order to understand it. Next, make sure that if you have a retainer agreement, it is clear what that agreement is. That it is an evergreen agreement, meaning that they're supposed to pay you $5,000 or $2,000 or whatever the number is, and that amount of money will stay in your client trust account, and that they're obligated to pay you currently on all new billings. That evergreen amount will be used at the very end and not until then. Or that you have a nominal retainer agreement, that is a nominal amount that they're to pay you now for you to get started, and that they are to honor your billing statements on a regular monthly basis. Let them know that the agreement is a two-way street. One, you have certain obligations to be competent, to treat them fairly, to address their issues timely, and to be very responsive to their inquiries. But that, two, the fee agreement puts certain responsibilities on them as well. One, to be candid with you, to be truthful. Two, to submit to you all the documents that you request in order to perform your services. And three, to pay your bill in accordance with the agreement. And that usually means every 30 days. Next, point out to them in the agreement what the consequences are of their not honoring their part of the agreement. The ultimate consequence is that you will withdraw from representation. Now, most lawyers don't like to withdraw. Most lawyers will continue to work because they feel obligated to do so as a result of the agreement. They find the client attractive and want to serve the needs of the client, or they find the matter intellectually challenging and they want to do the work. But this ignores the fact that this is a business. Parenthetically, let me say that the business of law is a phrase that I trademarked and still have registered since 1995. The fact that in 1995 lawyers never used the word business and profession in the same sentence is remarkable. Our clients run their life in a business-like way, and so should we. Translated, what that means is that you have to take a look at what your clients owe you. and not allow them to increase the amounts they owe you with disregard. You have to pay attention to that. You have to talk to them about them honoring their agreement. If they're not going to honor their agreement, there is no reason for you to continue the representation. Translated into my own world, what I say is, if my clients want to be slow in their payments, if my clients want to disregard the commitment that they've made to me, then I'd rather be on my bike, riding out on Pacific Coast Highway, enjoying the ocean and the sun, and thinking about new ways to market my services to people who will value and appreciate those services. Failure to pay your bill, under most circumstances, except where the company is going south, meaning bankruptcy or having significant cash flow problems for economic reasons outside of their own control, is merely evidence that they don't value your service. They don't appreciate what you're doing for them. They cannot tie the value of your bill to the benefit that they've received. And under those circumstances, either you've done a very poor job of education, or certainly you've done a very poor job of running your own business. And so, it seems to me that you have to be proactive in pursuing collections. You have to be proactive in addressing your clients and their need to honor their agreement with you. Call me if you've got any questions about this issue. Call me if you've got a different opinion. I would welcome the dialogue with you. Take a look at my book to see how, at least in my opinion, you can determine from the very first session you have with your client whether they'll pay you on an ongoing basis and clearly at the end of your representation. Be sure that you address the issue of collecting your accounts receivable. Do not put it off. It is this issue that will determine whether you make money or not make money. It is this issue that will determine whether you continue in this decade to practice law or have to turn to a different profession. Thanks for joining us today.